Okay, so welcome. This is a very basic 101 copyright law program for artists, photographers, writers, software programmers, and all other kinds of creative types. One question, first of all, how many graphic artists do we have here? Just let me say a show of hands, like art, photographers? A lot of photographers, not surprised there. Artists? Copy, okay, yeah, okay. Writers, yeah, a lot of writers, there we go. Software people, anybody doing computer software code? That's good, I don't understand a lot of, okay. Well, I understand a little bit about that stuff, we'll talk. Are there any Republicans in this room? That does not surprise me. This tends to be a very politically focused group of people, and that's perfectly okay, because I don't do political humor anyway, that's not my thing. But my name is Cliff, I am an attorney. I can't really say I'm a copyright specialist, but I've worked with creative people all my life, and I have also the author of a number of books and works, and since I'm too cheap to hire an attorney to represent me, I have been negotiating my own agreements for the last 30 years, and sometimes with good results and sometimes with bad results. So we're going to be talking a lot about what I do right and what I do wrong. If I could just ask you to please hold your questions until the very end. We will have a very generous period of time for questions and answers, with the understanding that I cannot answer all the questions that you have. This area of the law tends to be very, very what we call fact-specific. This is not an area, there are some areas of the law where if you just understand the general rules, you kind of know what to do, but this is not one of them. This is one of those where you kind of have to know the specific cases that answer specific questions, and while I can do that in a lot of cases, I can't do that in all cases. So just be patient with me. If I cannot answer a question, I'll try to refer you to somebody who's a little bit more focused and specialized and who can answer your question. The other favor, again, for people who just walked in, please turn your cell phones off or put them on vibrate or something. We are taping this for a YouTube channel and for some websites that have requested this specific content. And if in the middle of my presentation we hear something going ding, 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 I do not have the rights to your ringtone. So I have to charge you for that, a licensing fee. So please, do that and then we'll get along okay. So copyright basics, copyright 101, let's get started. Okay, first of all, now you know that I am a lawyer. If I needed to prove that, there we go. First of all, I am very much a friend of the SCORE organization. I am not myself a SCORE counselor or employee. So if you listen to something I say and you think it's good advice and you apply it and it doesn't work out and you get sued and you file for bankruptcy and your wife, spouse leaves you and your dog bites you and you end up living in a diaper box under the Brooklyn Bridge, you cannot sue SCORE. Frankly, you can't sue me either. I'm an attorney. Go try that. So you really can't sue anybody, you're SOL. The second disclaimer, which is the more important, which is, well, we're going to be going into a lot of legal information in this program. I don't really know any one of you well enough to give you one-on-one advice. So, I mean, it's general information and it's good information, but at the same time, this is not the same as what you would get from someone you are actually paying to represent you and draft your contract for you. So just keep that in mind. This is very general stuff. It's not really something you can rely on as one-on-one. I'd have to know you a lot better and a lot longer before I could really give you some one-on-one advice, and yes, charge you some money. Okay, so let's begin. Okay, what is copyright? Here's my metaphor. Okay, since you guys are kind of visual people, I thought it might be nice to begin with a little visualizing exercise here. We're going to be a little California here. Close your eyes, if you will. Not you, not the videographer, no, please keep your eyes open. No, the rest of you people, keep your eyes closed, okay? And just, if you will, picture you're sitting in front of a table, and sitting on that table is a famous work of art, something everybody would recognize, the Mona Lisa, Edvard Munch's The Scream, pick your favorite. I mean, you can do this for any kind of work, but I think it works better with graphic work, something you can visualize. Picture that this painting, this work of art, this photo, is sitting on this table. Now, picture about 2 or 3 feet above the painting or the photo, picture a hologram, a three-dimensional thing that looks exactly like the photo, the painting on the table, but it's separate. It's floating in the air above it, and it's not tangible. You can stick your hand through it. You can't feel it, you can't touch it, but it looks exactly. It's a perfect reproduction of the photo or the painting that's sitting on the table. Okay, now please open your eyes again. Sir, wake up. Sorry, okay, thank you. Just I worry about people who don't come back, early enough. I mean, some of you guys survived the '60s. I can see that from the audience. I worry about that. You're creating new works of art here during this program, which you really can't do because I own the rights. Okay, but seriously, so you have that hologram metaphor is the best way that I can help you visualize what a copyright is. A copyright is something intangible. You can't touch it, you can't feel it. It's a set of legal rights, and we'll talk specifically what they are in a few minutes. But while it is based on the work that you have created or the work that's on the table, it is not the work itself. It's something separate. It looks exactly like the work, but it's something entirely different. So if someone comes along and buys that painting, you sell the Mona Lisa to somebody else, hopefully for a good sum of change, unless you also sell the hologram stays with you. That's the message. You can sell the painting, the photo, at an art fair or an arts and crafts fair or something like that, but unless you also specifically assign the copyright to it, the copyright remains with you. The copyright floats around free and independent of the underlying physical work. That's the message, and that's why I use that hologram metaphor. It's a very nice way to help visualize what a copyright is. It's something that's based on a literary work, a work of art, a photo, a software program, whatever, but it's not the thing itself, the physical thing. It's something intangible, and it has its own set of rights that goes with it, okay? What is a copyright? Well, first of all, let me dispel one myth. Like, most people think of copyright as having to do with ownership. If you own the copyright, you own the work. That is not at all what copyright is. Copyright is something quite different. It's not. It is a number of things. It's a legal monopoly. Now, most of you know, if you know anything about the law at all, you know that in a capitalist society, we do not like monopolies. Monopolies throw the laws of economics out of whack, and whenever a company gets too big or takes over too parts of a market, we try to break it up. That's what the antitrust authorities in Washington, the Justice Department, are all about. But a copyright is a legal monopoly. It's a monopoly that the law grants you and says that for a particular period of time, you are the only person in the world who can profit from this creative work and these rights that are attached to it. You are the only person. Think of it as a legal monopoly. It gives you the right to exclude others from profiting from a creative work. So if you sell your painting and somebody takes a photograph of that paint, or somebody hands that photograph off to a lithography company, and they start running off, signed, lithographs unsigned, which they sell, on the web and stuff like that, you have the legal right to shut them down because they have invaded your copyright. It gives you the right to exclude others for a period of time from profiting from that work and from the rights in that work, okay? It is literally, copyright's one of those words, it really actually means what it says. It's the right to make copies. That's basically it. It's the right to publish the literary work. It's the right to make lithographs of the work of art. It is the right to make copies of the photo. That's exactly what it is. That's the right that you get with copyrights. In music, this is called the publishing rights. That's specifically there. If you're musicians, there's a million ways that they slice and dice these things, and we'll talk about that a little bit. And it's not just one thing. It's a bundle of rights. Now, to use another visual metaphor, picture in your mind that you are holding in your hand a bunch of pencils. Any number, six, half a dozen, whatever, okay? When you have copyright to a work, you are holding a bunch of different rights. It's not just one thing. If you're a musician, you have the publishing rights, but you also have, which is the right to publish the work and collect royalties when somebody uses it. The penny that Michael Jackson gets each time somebody sings Billie Jean, or his estate gets, I should say, when somebody sings Billie Jean. But you also have the performance rights, and these things can be separated. You don't have to give them all to somebody. You can give somebody some and give some to others. You can divide up these pencils and break them up between people. And we'll talk about specifically what those rights are. They vary depending on the type of work, and they change over time. This is a law that's constantly evolving. At the end of the program, I'm going to talk about some ways. There are a lot of people in the world today who feel that our copyright system is outdated, especially in the digital age, and needs to be drastically updated. And we're going to talk about some of the movements afoot to try to change the way copyright law is. What I'm talking about today may not be valid in a few years' time. This is a very fluid, evolving area of the law. So what does copyright protect? Okay, what attaches to it? What can you copyright? Okay, original works of authorship. The key word here is original. you cannot copyright somebody else's stuff. It has to be yours, something that you have created. If you're the photographer, you took the photo. If you're the author, you wrote the book or the poem, whatever it is. Literary, dramatic, musical, and artistic works, poetry, novels, movies, songs, software, and beginning in 1990, architecture. If I'm an architect, and I, like Frank Gehry, and I design the thing in Bilbao, the art museum in Bilbao, you can copyright in the United States a building that was constructed after, I think, January 1 of 1990. You can, for a reason. That's important for you photographers who are taking pictures of some of these new buildings. That's an important thing for you guys to know. If you're taking a picture of a building from 1850, no worries if it's a public building. But if you're doing a building that was made in 1995, you might have to inquire a little bit about copyright. What it does not protect is ideas and intangible things. So if you have an idea for a sculpture of Cliff Enneco in the pose of David, like the Michelangelo sculpture. I mean, that's kind of a cool idea. I might actually let you do that, actually, but of course it can't be anatomically correct. I can't imagine, only because I can't imagine anybody buying it. I mean, I don't care about the legality, but I don't think anybody's going to buy a picture of this. They might. I mean, it could be maybe a parody or something like that. But you cannot copyright an intangible something. It has to be reduced to a physical form in some way. A work of art, a poem, a painting, a manuscript. It doesn't have to be published. We'll talk about that in a minute. Although it may protect the ways the ideas are expressed, the tangible expression of those ideas, the idea itself cannot be copyrighted. We believe in freedom of ideas here. Okay, I apologize for the size of the type here. These are some things that you maybe can copyright. Your website, well, you cannot copyright a website, but you can copyright the original content. How many of you here have a website? Okay, keep your hands up. How many of you have the copyright notice at the bottom of each web page? Copyright whatever, Clifford R. Enneco, all rights reserved. Okay, most of you kept your hands up. Very good. That's something. Oh, those of you, thank you. Put your hands down now. Some of the, it's like Simon Says. So you have to watch out for this. Sometimes I kind of lose track, and 10 minutes later, the hands are still up there. People, you artists are actually very much conformists, by the way. You don't realize that. You're waiting for someone to give you permission. You guys are free spirits, man. I mean, you should be giving it back to me here a little bit. Okay. But seriously, but the original content, stuff that you have written and put up there, that's why you always put the copyright notice at the bottom of each page of your website. And you should definitely do that. I mean, your web guy can do that for pennies. This is not a big thing you're asking him or her to do. How about your domain name? No, you do not copyright domain names. What you have to do is you have to register it with a domain name registrar like GoDaddy or Network Solutions or one of these places. You might be able to get a federal trademark on your domain name. If it's unique and distinctive and doesn't describe what you do, there's a bunch of, this is not really a program on trademark law, but there's a bunch of categories of things that can be trademarked. But as long as you comply with that, you might be able to trademark it, but you can't copyright your domain name. How about your recipe for your killer baked beans? This is the summertime, so it's kind of appropriate to talk about this. If it's just a mere listing of ingredients, the answer is no, you cannot copyright it. Although if you do have secret ingredients, you might want to consider treating that as a trade secret. Like the formula for Coca-Cola. You can't really protect the recipe for Coca-Cola, but you can certainly keep it. Those of you know, the formula for Coca-Cola is actually kept in a safe at corporate headquarters in Atlanta, Georgia, and only a handful of executives have access to that safe, and they sign killer confidentiality agreements. I actually saw years ago one of the confidentiality agreements that these people have to sign. I mean, seriously, if these guys even breathe in their sleep the recipe for Coca-Cola, I mean, they'll be in prison for the rest of their life. I mean, it is horrible what they make these people sign. You can do that, but if it's accompanied by a substantial literary expression, have you ever wondered when you buy a cookbook why it is that the authors go into all this extraneous stuff about the recipes and how they came about it? I was sitting in this field in Tuscany and this idea came. You know what I'm talking about, right? What, you don't care. You just want to do the damn recipe, right? You just want to follow the instructions, right? Why? Because they're looking for copyright protection, because you can copyright that crap. You can, but you can't copyright just the listing of ingredients. You have to, but the literary expression of those ingredients, you absolutely can copyright, okay? And it's also if it's a collection of recipes. So obviously if Martha Stewart or somebody like that does a collection, the actual book itself can be copyrighted, all the content that's in there, okay? How about your company name? No, company names are product names are trademarks. not copyrights. Sometimes you can trademark them, sometimes you can't. But we're not in the copyright universe there, we're in the trademark universe. Anything involving a name is trademark world, not copyright world. How about a directory or database? Okay, tons of cases on this. In fact, quite a few Supreme Court cases. This is one of the thorniest areas of copyright law. I'm assuming nobody here is doing a directory or a database, but there might be some people out in video land who are. So the general law is yes, for the directory or database itself, sometimes the actual data can be copyrighted, but only if it's originally sourced data. So if I put together data in a certain format that I have created, the format might be copyrightable, but the actual listings of the publicly available information probably would not be. If you can picture that in your head. If anybody here is doing databases, I would suggest you talk to an attorney because there's a lot of very specific copyright cases that apply in that world. Because this gets very, as I say, this stuff gets very complicated when you talk about collections of publicly available information. Can the collection itself qualify for copyright treatment? It's a very thorny area of copyright law. Foreign works, okay? The U.S. is party to something called the Berne Convention, and about 95% of the world's countries have signed on to the Berne Convention. So if someone like Stieg Larsson, the Swedish author, who did the girl with the dragon tattoo, right? So when he publishes the U.S. edition of his work, that work will definitely be copyrighted here, as will all of his foreign translations. He doesn't have to do anything. It's automatically. There are a few countries that are not party to these conventions. So if someone gets a hold of Kim Jong-un's, who he is, the dictator of North Korea, I don't know if that is subject to copyright. It's really hard because only Cuba now has signed on to the Berne Convention just recently. So, Fidel Castro's memoirs, cool, no problem there. But if Kim Jong wants to do his memoirs here, I mean, I can't imagine who'd want to read them, but boring, Dictators generally have very boring lives, by the way. It's kind of boring to read about dictators, It's much more fun to read about, democratically elected people because they get into more trouble, quite frankly. Dictators, if someone really has problems with them, you just, it's kind of a short book, if you know what I'm saying. It's, in my prior life, I think I was a literary agent. Okay, when does copyright attach? Believe it or not, a lot of people think you have to actually file with the Copyright Office to get a copyright. Not true at all. The copyright attaches the minute you create the bloody thing. Whatever it is, as soon as you're finished with it, and of course no work of art is ever finished, but when you're ready to at least start offering it for sale, the copyright attaches at that moment. You don't have to really do anything to create a copyright. You do not have to register it, but there's a couple of things you have to do. You have to have some way of proving the date of publication when you first showed this work or made it available to the public. Now, in some cases, that's easy. If you put it up on your website, I believe that the website software will automatically record the date and time that certain content was posted. If that's not the case, ask your web person about that, and that will be admissible in a court of law. But you have to prove when the thing was published, because if someone else comes along and says, hey, dude, that's my work of art. You ripped me off. That's not your original stuff. I did this 5 years ago. And they got some documentation saying that they did this 5 years ago. You got to have something to come back with. So you got to find some way. The reason why people register things with the Copyright Office is because they want to prove the date of publication. If you file and register with the Copyright Office, the date that comes back on their acceptance form is the date of publication. And that will beat anything in a court of law. This is why people register with the Copyright Office. But there are some very good reasons why you might not want to register with the Copyright Office. Because once you register with the Copyright Office, your work goes into the Library of Congress and it becomes publicly available. And there are people out there called copyright trolls. And some of them work for very large, publishing companies. They're not just, sleazy people working out of caves in North Korea. These are sometimes serious people. Sometimes publishing companies have people that do this, that they pay to do this, to sort of look through the copyright records, looking for new, interesting ideas that they can rip off. So maybe you don't want to publish with the Copyright Office. That's okay if that's the case, especially if you have like an unpublished manuscript for a new type of detective novel with a new type of detective or something like that. You really don't want to release that because even though they can't steal the text of the book, the idea of the detective somebody else could rip off or something, maybe that's a situation you face. You don't want to register with the Copyright Office, but you still have to prove the date of publication. So there's two things you have to do. You always have to include the statutory copyright notice on each work, or if it's a multi-page work like a book or a novel, each individual page has to have the statutory copyright notice, and that is it. I put it up there, right there for you, the letter C. In fact, you can also look at the bottom. The letter C, the year of creation, by your name, all rights reserved. The all rights reserved language is not part of the copyright notice, but I think it's a great idea to have that in there, because what that says in English is whatever rights I haven't sold to someone else, they belong to me. Whatever I haven't sold to somebody else, hold off your questions, please, till the end. Whatever rights I have not sold off to somebody else, I got them. I'm the rights holder. So if you want to use my stuff, I'm the guy you got to deal with, or the person you have to deal with. Everybody with me on this? That's what this does. Now, you don't have to use the C in a circle. You can spell the word out, copyright, because in PowerPoint, when you do a footer, you cannot use the copyright symbol. So spelling out. Some people also do COPR, period, 2050, and that's okay too. Anything that says to the world copyright will work. Okay, the C in the circle is the best thing, though, if you can do it. What's a poor person's, it used to be called poor man's copyright, but I don't like using sexist language. Poor person's copyright or a poor man's copyright. This applies mostly to authors. You really can't do this with photographs or stuff, but for literary works, it's really well. What you do is you take your manuscript, you do a photocopy of it, and then what you do is you mail it to yourself, is what you do. And when it comes in the mail, hopefully it does, you don't open the envelope. Because let's face it, for two reasons. Number one, you already know what's in there. But also, number two, what you really want is the postmark. That's what you want. Because the postmark is your date of publication. You can prove it's a sealed envelope, has not been opened, has not been, and please, by the way, when you do poor person's copyright, always make sure you seal the envelope. Don't just do the clasp envelope and don't, take a minute out. I know it's gross, but lick the thing, and seal it. Because if it's one of those things where someone can just open the clasp, that's not going to really help you. The whole idea is this is a sealed envelope. It's been sealed since time immemorial, and there's the postmark. So as at this date, you can prove that this work was in existence on that date. That's all you're trying to do with poor person's copyright. It doesn't work as well with photos, obviously, or works of art. If you take the Mona Lisa and put it in an envelope and seal it, well, you're not going to be able to show it to anybody unless you open the envelope. And so that's why it really only applies to literary works and other things where you can make multiple copies. A photograph you probably could actually, because you can do multiple iterations of a photo. But an original work, an oil painting or something, that's not going to work all that effectively. Okay, again, the goal here is to be able to establish to a court's satisfaction the date on which you first finished this and released it to the public. That's what you're trying to do. Okay. How do you register your copyright? You must submit this to Copyright Office. Three things. The correct application forms. There are currently about 15 application forms for different types of works. The good news is, by the way, the copyright.gov site is very, very good. I have to say that they really make this easy for folks. You basically go, and the categories are right there. You click on the category that applies, and boom, there's the correct application form right there. They've really done a very good job with this. It's hard to make mistakes in this area. The only people that have problems with this are people doing like multimedia type of things, like Bjork or Yoko Ono, who does these things that are they're part movies, part theater productions, part artworks. They're the ones who the Copyright Office hates, quite frankly, because they got to copyright each part separately. These people need a copyright lawyer. If you're doing multimedia installations, you probably need a copyright lawyer. But for anybody else, you can just use there is a form for just about everything. It's very hard to make a mistake there. You have to send a non-returnable copy of the work, and this has to be in paper, graphic, or audio. They will not accept a CD-ROM or electronic submission on that. It has to be a tangible, physical work. And they will give you guidance, actually. If you're doing something that's a little sort of, contemporary, they may give you they'll give you lots of examples on their website of what they will accept. But it cannot be a CD-ROM or a floppy disk. You can't just send that to them. Although you can register electronically, the submission, what they call the required submit, must be a tangible bricks and mortar physical manifestation of the work. And the filing fees are all over the place, but most of them are between 40 and 80 bucks. For the most part. Cash in the barrelhead or credit card. Okay, who owns the copyright, okay, whether you register it or not? The author or creator, that's you. Unless you sell it to somebody else, that hologram always stays with you. And no one can do a thing about that, even if they own the work, even if they destroy the work. Somebody buys it, and they hate it, and their house gets looted and the work gets destroyed, you still own the hologram. You still own the copyright to that work, even though the actual physical work no longer exists. The owner of the physical work has the right to do that, but they cannot do anything to your copyright. Okay? His or her heirs and assigns by will. So let's say you're rummaging, you're cleaning out your mother's house, and there in a trunk is an old diary from your great-grandmother, and it's her memoirs of when she survived the Holocaust. You know a publisher is going to want this diary, right? Do you have the right to copyright your great-grandma's or your grandma's or great-grandma's Holocaust diary? Do you have the right to do that? Well, the answer is, if she left the diary to you, the answer is yes. If she didn't, the answer is no. I'm assuming she's passed, she's gone, right? What you have to do is you have to see who owns the work under the estate. And what you have to do is you have to look at your mother's will. I'm assuming she's gone. That's why you're cleaning out her house. If she's still alive, she's going to object to that, probably. Seriously, one of the surest ways to get your mom mad at you, cleaning out her house while she's still there. Trust me on this. I found this one out the hard way, people. When she's still there, you can't take stuff out of that house with her sitting there. It just does not fly. It does not fly. Okay? But I'm assuming she's gone. So you got to go back and you got to look at the will. And most wills have two sections. They're what they call specific bequests. My house goes to this person. My jewelry goes to this person. That kind of thing. And then at the very end, there's a clause that says anything I haven't described in the above paragraphs goes as follows. We call that the residuary estate, and that's probably where this diary is going to fall. It's probably going to be in the residuary estate. So you want to read that language, and if the residuary estate says any property that I've not described above will go to my children in equal portions. Well, you're not going to split the diary up, and you have two. Let's say you have a brother and a sister, so there's three of you. You're not going to take the diary and rip it apart. What it means is that the three of you own the diary as a partnership. So if you're going to sell the diary to a publisher and have it published, all three of you have to assign the copyright. If the brother says, no, I don't want that, there's some private stuff in there I would not want to be disclosed about how she had an affair with a Gestapo guard, that would not look good in that thing. And seriously, hey, all kinds of stuff surface when you find an old diary in a trunk. That's a heart attack moment. I actually know people who have had their attorneys read it first before they do, to make sure, because there could be stuff in there that you might not want to, have published. You learn things about your relatives you never knew before. These things can happen. But the point of the matter is that if the diary was up to all three of you have to go along with the deal. If one of you says, no, we don't want this, you cannot publish great-grandma's diary, no matter how great the literary value might otherwise be. That's the best example I can think of for something like that. You cannot copyright somebody else's work. You have to have the legal rights to it. Although you don't have to be the author. If you're an heir or an assigned by will, and then you can prove that, that you can prove the chain of ownership down to you, you can copyright the diary. You absolutely could, but you have to go through that. Even if you're a minor, by the way. So let's say some 18-year-old writes a sex novel that becomes, a world-famous sensation. Hey, could happen. Although from what I've seen of today's 18-year-olds, we don't have to worry about that so much. I don't think they have the imagination for it. That's okay. I don't care. They can't sue me. It's a generic statement, not targeting any specific individual. There's law on this. Trust me. You can, an 18-year-old or a 16-year-old could copyright, something. My memoirs of junior high school, my junior high school story or whatever. You could definitely do it. The only thing is, though, he might not be legally able to sell or license the rights because he's not of the age of majority yet. He's not at the age of consent. In Connecticut, I believe you have to be 21 before you can legally be bound by a contract. I think that's the rule in most states. So mom and dad are going to have to, although let me tell you, if the royalties are the right amount, mom and dad will sign. Trust me about this. There will not be an issue. Of course, they're going to want to cut. So that's why the 18-year-old and the 16-year-old has to have a lawyer, absolutely, because mom and dad, this is your college fund. The hell it is, $5 billion? I'm not going to college, baby. Those discussions can happen in families, Got to watch out for this. His or her employer. If you work for somebody else and you create something as part of your job duties, there's something called the work made for hire doctrine, which we're going to talk in a minute, where your employer automatically owns the right to that. If you did it during working hours using their equipment and it's for their purpose, so you create some beautiful advertising copy, that a lot of other companies would be interested in, you cannot copyright that, you cannot sell that. Your employer owns that. Not the owner of the physical object. So if you sell your Mona Lisa to somebody else, the physical painting, they cannot copyright that unless they actually buy the copyright as part of that, okay? And also, if you are an independent contractor, do we have any consultants here? Do we have any people? Okay, you should be listening up to this. If you're a 1099 person and you create a work of art or something, or a brochure or something for a client, unless you specifically assign your copyright to the client in writing, you still own the copyright to that work. Your client cannot do a bloody thing about that. So when I'm representing clients who are consultants, do I put in an assignment of rights clause? No. I want the other side to raise that as an issue. A lot of people don't look at these things. They roll over, they sign them, and guess what? Bada bing, my client has not been paid on time. The company's trying to screw around with them. First line of attack. Well, you realize, of course, my client still owns the copyright to the brochure. They're going to use it for all their other clients, maybe including some of your information. I really think you ought to pay them at this point. If you pay them, my client, what they're owed, they'll assign the copyright over to you. But otherwise, my client's going to use this to try to make up for what they lost because you're not paying them. That's what I want. Now, of course, I'm representing the client. I want everything nailed down to Tuesday. The copyright gets assigned the moment you put pen to paper, even if you don't get paid. It depends on which side of the fence you're on. But always remember that if you're an independent contractor, the copyright, the work made for hire doctrine does not apply to you. And we'll talk more about that later. It's a very important point. Okay, what does copyright give you? It gives you the exclusive right to publish and make copies of the work. Remember, the right to make copies. That's basically what the copyright is. The exclusive right to profit from the work and any derivative works. That's a key concept. We're going to talk a lot about derivative works in a few minutes. Derivative work can be more valuable than the work itself, sometimes. The exclusive right to edit, alter, or change the work. So if you sell your Mona Lisa, the physical painting, to somebody else, and they draw a mustache on it, like Marcel Duchamp, remember the conceptualist artist did, right? They can't do that. You can actually sue them and get them to pay to restore the work to its initial condition. There's a famous Supreme Court case on that. They cannot alter or change it. They can burn it, they can destroy it, that they can do, but they can't change it in any way without your approval. The exclusive right to edit, so for a literary work, they can't, if you've written a best-selling novel and you send it to the publisher, technically, they cannot edit that without your approval. Of course, if you read the fine print of your publishing contract, you've given them the right to do that. But without that clause in the contract, they don't have the right to edit without your approval. And also the exclusive right to sue others who infringe your copyright and make them pay through the nose. That's what copyright gets you. How do you profit from copyright? Well, there's really only two ways. And again, I apologize for the size of the type, but I didn't want to do 2 slides on this. You can either sell your copyright or assign it. Copyrights are usually called assignments, but sale and assignment are basically the same thing. Or you can license, sale or license. Those are the only 2 ways that you can transfer your copyright to somebody else. Licensing your copyright is a better way to go. But first, let's look at the sale. When you sell your copyright, your hologram, you no longer own it. You now have given to this other person all those rights that I had on my preceding slide. You cannot do anything. So, and this happens a lot. You're an author, you write a manuscript, you send it to your publisher. A year later, you find out someone's ripping off your book. You call your publisher and say, hey, they're ripping us off over here. You're losing money here too. I want you guys to sue these SOBs. And they just don't want to do it. You can't do anything about it. You cannot sue that person because you gave away that right to your publisher. And if they don't want to exercise that right, you can't overrule them. When you sell your copyright, you have given away everything, that entire handful of pencils, you have given to the other person. That's part of what you did, okay? Remember Brian Epstein, the manager of the Beatles in the early years? You all know this story. Biggest mistake he ever made was he didn't understand this difference. He thought that he was licensing the rights to the Beatles songs to, I think it was BMI or one of the big British music publishers. He ended up assigning those rights. So that's why Michael Jackson, you ever want to know why Michael Jackson got rights to all the early Beatles songs? That's how it happened. Because Brian Epstein really wasn't a very sophisticated business person, didn't understand this difference, and that's why the Beatles for years did not have rights to a lot of their own songs for many years until they formed Apple. That's one of the reasons they formed Apple, was to make sure that that problem would never happen again. That's what they did. When you sell a copyright, you don't own it. Now, of course, if a publisher is going to publish your book and your best-selling novel and take a risk on you, they're going to want you to assign the copyright to them, and there's no way you can get around that. I'll be very honest with you. I've never been successful in negotiating an assignment of rights clause out of one of my publishing agreements, as hard as I try. But there are some things that you can do. Number one, I always make sure in the contract there's a clause in there that says that in the event you are no longer actively publishing the book, you let the book go out of print, or if sales fall below X copies per year, the rights automatically revert to me. In other words, if you're no longer interested in this book, I want it back. Believe it or not, unless you put that language in, that doesn't automatically happen. Now, most publishers, at least book publishers, I will tell you, will do it anyway because they don't really want the rights at all, okay? Although that's actually very stupid, to be honest with you, because if I ever drop dead tomorrow, the value of my rights are going to skyrocket. You might want to have some rights to some of my out-of-print books if you're a publisher, but quite frankly, I'm not Stephen King, so Stephen King might be able to get away with something like that, but a Cliff Ennico is not going to get away with that. But I always put that clause in my contract. If they're not going to push the book, if they're not going to market and promote it, I want the rights back. I can do a better job or I'll find somebody else. And I've got one book right now that's on its 4th publisher, believe it or not. And it still sells very well. I do not know why this happens, but for some reason, after a few years, the publisher, usually what happens is the publisher changes their strategic direction. It's a career book. It's for young lawyers, basically, how to interview for a legal job. So sometimes they get out of that market, whatever, and they don't really want this book anymore, so they give it. I always make sure you put a reversion clause in that says that if things aren't working out, if you don't really want him, I get the rights back for $1. I'm not going to pay for this. Although, what most book publishers will do, I will warn you about this, if you try to put a reversion clause in the contract, they will say, okay, but then we want you to buy whatever our remaining inventory is at cost. Do you have any idea, ladies and gentlemen, how much space 5,000 books takes up in your basement? You may think for a minute, that's a good deal, but before I would do anything like this, I always tell my clients, before you agree to something like that, look at your basement, do some measurements here, your garage, your attic, because 5,000 books takes up a lot of space. Go downstairs, look at those shelves full of books, take a thing, see how much physical space 5,000 books takes up. It's a lot of space. It would probably fill your basement up 2/3. Seriously, it's a lot, depending on how many are in a crate. Seriously, be very careful before you agree to that. It sounds like a good deal, but it may make your spouse angry at you for years. Okay, so there we go. Okay. Be very careful when posting on social media. Some of you guys know about this. I know some of you guys have questions about this. Some social media sites, especially Facebook's notorious for this, has a clause in their user's agreement that says that any content you post on the Facebook site, they own. You have assigned your copyright to them. When you post, now I understand why they're doing that. They're not really bad people, and I'm not going to knock Facebook, but what they're saying here is, if we see that you've done something really cool on Facebook and we want to promote that to the entire community, or if we want to publish a book on the 1,000 greatest Facebook postings ever, and we want to include your thing, we don't want to have to come back to you and get permission. So by giving us this language, by signing on to this, you are giving us permission now to do stuff like that. So it actually is for your benefit that they have that in there. But unfortunately, the way they've worded that is so vague and open-ended that a lot of artists and photographers have asked me, Cliff, if I take my photograph and put it up on my Facebook page, do they technically own the rights to it? And the answer technically is yes. If Mark Zuckerberg were ever to drop dead and some evil genius takes over Facebook, we can name names, and wants to steal copyrights to photographs and artworks that are posted on the site, technically that language in the user's agreement gives Facebook the right to do that. So I tell clients, don't post your artwork on Facebook. Instead, post a link to your website and have it there. Because when it's on your website, that's your rules, that's your user's agreement, your privacy policy, and that takes you out of the Facebook user's agreement. So those of you who are artists and photographers, by all means promote your work on Facebook, but until they change the language in their user's agreement, I would not put the work itself up on Facebook, because you might get caught up in that language. Okay. Let's talk about works made for hire for a second. If a work was created in the course of someone's employment, and by employment I mean W-2, they withhold taxes and everything, the employer automatically owns copyright in the work, but not so for independent contractors. The independent contractors must specifically assign their copyright to a client. And the famous case here is the Reed case. This was a U.S. Supreme Court case from 1989. For those of you who are interested in legal history, this was the Thurgood Marshall's last opinion for the Supreme Court before he retired. He retired right after he did this opinion in 1989. Reed was a sculptor. He was hired by a group in Washington in the 80s to do a sculpture of a homeless person for one of the public squares in Washington, D.C. And he did, and it was very edgy and very controversial. A lot of people did not like it. Got a lot of negative publicity on this. And it wasn't like the Vietnam Wall, where there was a lot of negative publicity at first, but then people got it. nobody was getting this thing. It was just one butt ugly sculpture. It just was. So the committee, this organization, went back to the artist and said, look, we brought in some other people. They feel that if you just make these few modifications, we won't be getting a lot of this criticism anymore. Would you please make these? Now, he'd already been paid. They had paid him to do the sculpture. He said, no, this is my vision, this is my work, I don't want to change a thing, this was my vision. You know, if you want to take it down and put it in storage somewhere, that's fine, but, you know, but I'm not going to change anything here, and you cannot make changes yourself. Well, they went ahead anyway, and they got somebody else to make these changes, and he sued them for infringing his copyright, even though he was paid in full for the sculpture. Okay? The problem, the lawyer for this nonprofit organization did not put in an assignment of rights clause. Was the problem. Case went all the way to the Supreme Court, and Thurgood Marshall, in his opinion, said that even though Reed was paid in full for the sculpture, because he did not assign his copyright to the sculpture, the hologram, right, he could prevent that organization from making those changes. He even said they could have taken the work and buried it somewhere, but they couldn't make changes to it without Reed's specific consent. So that's the famous Reed case. You'll hear about it referred to in copyright circles. A lot of articles on it. Still the law today. What I recommend my independent contractors to do when a client asks them to do an assignment of rights clause, I say fine, but make it conditional on payment. Instead of saying, I hereby assign my copyright to name of client, I tell people, provided that I receive payment in full, therefore, I will assign my rights to. Make it conditioned on payment. Because what generally happens here is that you assign your copyright and then you don't get paid for some reason. And that's not a good situation to be in. So you want to try to tie those two things together as much as you can, or just don't have it in the contract at all. Let the client bring it up. Okay. Okay. But copyright is not forever. Is not forever. It only lasts for a period of years. After that, the work goes into what we call the public domain, which means that anybody, you don't lose your rights. It's just that they are no longer exclusive. When something goes into the public domain, you can still continue to publish the work and do whatever, and most publishers will probably want to work with you, but other people can publish it as well. Are people seeing in the music stores now a lot of compilations of 60s and 70s music by artists that were like in different record labels and stuff like that? You've seen this starting now? That's because these things are going off copyright. They're going into public domain. So a lot of record companies are now doing CDs with Elton John and the Beatles, you know, people that were all on different labels, and they couldn't do it before now because of the copyrights. That's what's starting to happen now. This gets very, very complicated. For works created after January 1, 1978, copyright protection lasts for the life of the author plus an additional 70 years. So if you write a book right now and you drop dead to next year, 2016, okay, your copyright lasts until 2086, okay, the day before you drop dead, okay? For an anonymous work, a pseudonymous work, or a work made for hire, the copyright endures for 95 years, or 120 years from the year of its creation, or 95 years, whichever expires first. I can't think of a really good example of that, but sometimes you find like collective works and stuff where the authorship is hard to pin down, and that's probably why they did that. For works published prior to January 1, 1978, you have to look at the copyright law in effect when the work was first published, because that's the law that applies, is the law that was in effect the date that the work was first published. So for example, you find this wonderful photo from 1923, and you want to do something with it, you know, has the copyright expired? And let's assume you can find out who the copyright owner is. It's on the back of the thing. Let's just assume that that's not a problem, okay? There are some wonderful web pages, by the way, and if you want, I don't normally give my slides out to people because there's a lot of people, mostly lawyers, that want to rip me off. But if you want to take a photo of this slide, please go ahead, because there's a couple, Cornell University has a beautiful set of web pages to help people that are looking to copyright mostly literary works, you know, scholarly works and things like that. And they actually have a chart showing for different kinds of works created at different years what the term is. It's a wonderful little thing. Or if you want, I'll leave this slide up for a minute. You can write these things down. These are actually charts that show you if it's a phonograph record, 1923 to 1960, here's exactly when the copyright's going to expire. These are very, very useful web pages. And I would just make copies of them however you want to do it. But be careful. Don't just assume. So for example, let me ask you, how many people here think that the Bible is public domain? How many people think it is? Okay. How many people here think no? Okay. When was the Bible written? 2,000 years ago. You think you're pretty safe, right? sometimes longer, right? 3,000 years for the Old Testament and stuff like that, and maybe 2,000 for the New Testament, right? But that's the original version in Hebrew or Aramaic. If I do a Bible translation today, that translation is copyrighted. Even though the underlying work might be public domain, my Cliff Enico Bible, the revised Cliff Enico Standard Version of the Bible, there are some versions of the Bible that are still under copyright because of the year that they were created. So you got to watch out for translations and also watch out for subsequent editions. Have you ever seen in a textbook, you turn to the copyright page and it says copyright 1961, 1962, 1963. You ever see that in the public? Here's why that happens, okay? Subsequent editions of a work can be separately copyrighted. Okay? So if I have a textbook and I change a few pages around, I can copyright that independently as the second edition. And some textbooks now are in their 30th, 40th editions, right? If you know about that. That's how they can keep the copy. That's how the publishers game the copyright term. By doing this every year, you keep pushing that period of time back until the author drops dead. That's how they do that. And it's perfectly legal, by the way, to do that. But not if there was only editorial changes. So if all I do is correct typos and maybe put a few commas and semicolons in, that's not a subsequent edition. But if I add a new chapter, that's a new edition. So whenever I do a new edition of one of my works, I always make sure that there's new original content. There has to be new original content in order to play that game. Okay. So for example, if you go on my website, you're going to hear about this a lot. I have an outline. It's only 7 pages long. It's a PDF file. It's called Demystifying the Business Organization. It basically talks about the differences between corporations and LLCs and S corporations and how they differ. This thing has been downloaded over 100,000 times from my website. It's been translated into 6 languages. It's being translated into Chinese. I have a professor at one of the Chinese universities that wants to use it. And I gave him permission. I said, by all means translate it, but I want to see the translation. I can't wait for this thing to come. It's going to be like 120 pages, I think, is what it's going to be. But I want to see the translation. I want to see what it looks like in Chinese. I'm just curious that way. I assume he's doing it right. I mean, I haven't a clue. He seems like a knowledgeable guy. But, and by the way, I've never made a single penny off of this. You can download it for free from my website. It's cliffenico.com if you're interested in it. But I will tell you that every year I always change it. It's never the same. So if you look at the bottom, it says copyright 1996 to 2015. Every year I make changes to it, and that's how I can get away with that and keep extending that copyright date out. Okay? So that's the law. Now let's talk about derivative works. Okay? Derivative works and fair use are the 2 most complicated areas of copyright law. We'll take derivative works first. When you have a copyright of a work, copyright does not just protect that work, but the works that are based on that work, whether you do them or whether somebody else does them. And those are called derivative works. Wow. So if I write a novel, with certain characters, and you decide you like this so much that you write your own novel with these same characters in them, just because you love them so much. And there's a name for this, by the way. It's called fan fiction. For those of you who don't know, you ever heard this term? Fan fiction. People writing novels about Star Trek where Spock and Kirk are having more than just a platonic relationship, that kind of thing. Seriously, there are things like that out there. And there are some rules on that, which we'll go into in a minute. But if you have a copyright on a work, so for example, here's the thing I remember. There's this, some of you guys are old enough to remember this, but back in the 80s, there was an ad on radio it was one of the wine companies, one of the wine vineyards out in California. It's this sleazy guy who's trying to impress a first date. They're at some expensive restaurant, and the girl asks him, so what kind of books do you read? What's the latest book that you read? And he says, clearly not a literary type. He says, the novelization of Saturday Night Fever. That's his answer. That would be an example of a derivative work. Somebody who took the movie and made a novel, a prose fiction work out of it. A Broadway producer whose work is made into a movie. The screenplay would be considered a derivative work. Unless he specifically denies it, of course. And many Hollywood producers put that in their contracts, that specifically the movie is considered a separate work from the Broadway work. And the Broadway producer gets paid for that, obviously. But unless you specifically disclaim it, anybody who creates a work based on your work, that is called a derivative work, and so that's the thing. Now, of course, you can also assign the rights. So let me just go back for a second. Let me just make the point. So the author of a Broadway play, it's made into a movie, the Broadway producer still has the copyright on the screenplay unless, of course, they assign that specific right to the movie producer, which they probably will do. The movie producer will insist on an assignment of rights clauses in their agreement, okay? But, and this is where law gets very interesting, the law also protects parodies of copyrighted works, and parodies can be copyrighted in their own right. So Marcel Duchamp, who drew the mustache on the Mona Lisa, that is an independently copyrightable work. Leonardo da Vinci, were he still alive today, would not have any rights to Marcel Duchamp's painting, I can't remember what it's called, some of you might know, of the Mona Lisa with the mustache. But there are two very famous cases here that go into this. Basically what the Supreme Court has said in a number of cases is that if the supposedly derivative work has transformational value, if the work can stand on its own feet as an independent literary or graphic work of art, it can be separately copyrightable, okay? So, for example, in the 1990s, a woman wrote, well, you all know Gone with the Wind, right? You all know the book, you know, Margaret Mitchell, right? Well, back in the 1990s, a woman, an African-American woman, wrote a version of the Gone with the Wind as told from the perspective of a slave on the Tara plantation, and not one of the slaves that was in Gone with the Wind, some other slave that wasn't mentioned in the original book. And some of the characters do make an appearance there. You know, what's her name? Right? And was it the Clark Gable and right? I'm sorry, Brett Butler, right, and all these people, they make their appearance, but she was very careful not to use any of the dialogue from the original Margaret Mitchell book. This was all original dialogue told from the perspective of a character that was not in the original book, but featuring some of the characters. In fact, she called it, the title was The Wind Done Gone. Clever as hell, if you think about that, right? Margaret Mitchell's estate sued. It went all the way to the Supreme Court, and the Supreme Court said no, because of all the things I just told you about, that this is a very valid parody, and they said that the publisher had every right to do this. This was a work that was independent. They did not owe royalties to Margaret Mitchell's estate because of this book. It was independent enough from the other work that it was not a derivative work. Now, in contrast, we have baby boom geezer Holden Caulfield, right? You all know who Holden Caulfield was, right? Catcher in the Rye. Some guy in Sweden, about 5 years ago, decided he would write a novel told from the perspective of Holden Caulfield as a 76-year-old guy. And baby boom geek. What happened to Holden Caulfield, right? What happened after the events in that book when he was a teenager, right? So this is a book, a novel based on him being 76 years old and what he turned into. And this didn't go to the Supreme Court. This went to the New York Federal District Court. But basically what they said there is because the character was not sufficiently independent of the Catcher in the Rye. He used some dialogue. There's references back to the original book where he quotes from the original book. The character was meant to be the same character, just older, right? Remember, in The Wind Done Gone, the narrator, the slave narrator, was not a character in the original book. Here it was. The court spent a lot of time on that one specific fact, and they said that this book was, that the Swedish company could definitely publish it here, but it was a derivative work. They had to pay royalties to J.D. Salinger's estate. So these are the two sort of polar cases, and I described them in this handout that I'm going to give you at the end of my program. But these are the two cases that will give you some idea of what's a transformational work and what isn't. What about fan fiction and mashups? Well, the good news is some publishing companies have actually done a very nice thing here. They've actually put up, so for example, J.K. Rowling, the author of the Harry Potter books, she actually has a web page where she basically sets out rules for fan fiction, for people that actually want to do books based on the Harry Potter characters. They say you can do this, but you can't do that. I mean, some of the authors and publishers are actually very helpful. The Star Trek people also have a very good website, I can't remember where it is, where they say you can do this. The characters have to behave in a way that the characters in the copyrighted works do, so Spock and Kirk cannot have the affair, you know, for example, but they can do other things as long as they don't violate their basic natures. So in other words, if Spock is going to turn into this ultra-violent guy, they got to make him a Klingon, basically, or someone who's known for violence, right? They got to do that in order to, seriously, there's actually all kinds of rules for fan fiction. Fan fiction is one of those crazy way out areas, and the other area is mashups. Anybody here, is anybody here a fan of Robot Chicken? Has anybody even heard of this show? Oh, Seriously, it is one of the best reasons to have Nickelodeon on your cable system. Seriously. You know how they have the Adult Swim at nights, you know, the grown-up cartoons and stuff? There's a show on there called Robot Chicken, which is basically, it's a claymation thing with action figures. What these people have done is they've gotten a lot of action figures from Star Wars and Star Trek and all these people. And what they do is they create these little, like, some of them are very short. They're like 5 seconds, 10 seconds long. These little vignettes involving the action figures. So, for example, they show one of the Imperial stormtroopers in Star Wars rather. He's taking his daughter along for Take Your Daughter to Work Day. And she's this little cute, you know, Betsy Boop doll and stuff. And of course, a whole battle with the rebels breaks out while he's there with his daughter and he's trying to protect this. It's absolutely hysterical stuff. But it's all based on copyrighted characters and copyrighted materials. These are called mashups online. Okay, now I happen to know the Robot Chicken people do a heck of a job getting permission to do stuff like this. You know, Darth Vader goes into therapy, you know, that kind of thing. That's the kind of stuff that they do. Seriously, look for this show. It's called Robot Chicken. Definitely a DVD rental from Netflix. It's one of the funniest things on television that I've ever seen. But what about that? Well, I think most of the movie producers, again, I always tell people there's copyright and there's common sense. If what you are doing is helping me promote my brand and my work, I don't really care that you're infringing my copyright. I'm not going to break down. A couple of years ago, some law school student did a website based on the 100 best books for law students. And he had 3 of my books in the top 10. And what he did was he took actual chapters from each one of these books and typed them and reproduced them verbatim on the website. Now, he put 3 of my books in the top 10. Do I want to shut this guy down? Now, technically, he is infringing my copyright. He took a whole paragraph from my book and put it up there, right? That's copyright infringement, if nothing else. But he's helping me out. He's telling law students around the world that these are 3 great books, and they're all written by the same guy. How bad is his other crap? You know, if these books are that good. I actually helped him. Not only did I give him permission, I actually sent him stuff, you know, to put. I didn't care. I was happy. Now, of course, if this was a website on the 100 worst law books of all time, I think the outcome there would have been a little different, don't you? So a lot depends on how you're doing it. I think one of the reasons why the Robot Chicken and people get away with a lot of this is because they're glorifying the underlying work. You know, how many people here remember all the plot details of the Star Wars movies of 30 years ago? I mean, I don't care about my memory's not that good, but I watched Robot Chicken and it reminds me, oh yeah, that did happen. Jabba the Hutt did do that and all that. You know, they're helping promote the original work. So I think a lot has to do here with intent and what your intent is when you're doing stuff. But also, always keep in mind, owners of highly popular works have lots more money than you do. So if they send you, and by the way, let's just say this right now, very rarely do people sue in court for copyright infringement. What they tend to do is they send you a nasty letter called a cease and desist letter. It's usually from their lawyer or something like that. So in situations where you're doing something that's a little dicey, but it's kind of, there really isn't any clear law, what I will sometimes tell clients to do is, well, okay, do it, but the minute you get a cease and desist letter, be prepared to shut down because you don't have the resources to fight Warner Brothers. You just simply don't. So just keep that in mind. You know, if what you're doing is good intent and they see that you're not hurting them, chances are nothing will happen. But just be prepared that they can send you this. See, the good news is they don't sue. They don't go right to court. They send you the letter and they give you a chance to do the right thing. And then, of course, you can maybe say, well, okay. Tell you what, though, I really think that, just so you know, I got 50,000 hits on this thing. I'm promoting the heck out of your work. Maybe we can do a license deal. It gives you a chance to turn into a business negotiation. So if you're doing something that's cutting edge like that, you know, do it, but be prepared for the cease and desist letter when it, you know, if and when it comes. Okay, now let's talk about fair use, and then we're done. You all know this. This deals with permissions. When can you use other people's stuff, and when can they use your stuff? Okay, here are the basic rules. Can other people use your copyrighted work without your permission? Short answer, no, unless you let them, unless you permit them. Next question, can you use other people's copyrighted work without their permission? Short answer, no, unless they let you, unless they permit you. Okay, any questions? That's fair use in a nutshell, by the way. That is the fair use doctrine in a nutshell. That's really what it is. Basically, if you're using somebody else's stuff, you got to get their permission. End of story. And they got to get your permission to use your stuff. Works both ways. Okay. But of course, as we know, there are books this thick about fair use, as we all know. You know, this is where things get very case specific, like I said at the very beginning of the talk. As long as you give due credit, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting. Journalists obviously have exemptions here, and scholarly. This is what got us through college. right? Because you know when you were in college and you wrote those research papers, quote unquote, those term papers, you stole like a bloody thief, didn't you? Sometimes there wasn't a single original word in any of your research papers, but as long as you did the footnotes that went on for pages and pages and pages, you were okay, as long as you gave credit. You weren't saying this was your stuff, you're just stealing 1,000 words of Cliff Enico. That's what you're doing, and as long as you give me credit, that's okay. And of course, nobody really cares about stuff, although I will tell you, hardly a week goes by that I don't get emails from professors who are doing like custom textbooks for their students that want to include articles of mine in there, and they always ask me for permission. And if you're going to do stuff like that, there is no academic exception. People think there's an academic exception. There isn't. If you're going to do something like that and publish a work under your name that includes something like mine, what's called a compilation, you have to get permission from all the people that you're compiling. And this comes off the copyright website, by the way. I didn't give attribution here, shame on me, but I am quoting them, and I'm doing it on the video here because I didn't have time. There are no legal rules permitting the use of a specific number of words, a certain number of musical notes, or a percentage of a work. There are no rules at all. So this is one of the biggest areas of misinformation in copyright. I hear it all the time. Well, Cliff, I've heard it said that if you use less than 50 words, you're okay. No, there's nothing at all like that. Nothing at all. There's no number of notes or number of words that are magical when it comes to fair. Now, fair use depends on all the facts and circumstances of a specific case, right? So you remember George Harrison, the Beatle, My Sweet Lord, right? Which infringed the copyright of the, what was it, the doo-wop song from the 1960s, He's So Fine, right? The chiffons, right? I mean, seriously, if you listen to it, you kind of got it because the main themes of the two songs were the same, but then they went in completely different directions. But because the main themes were the same, a court in England held that there was copyright infringement there, and he's been paying, his estate's still paying royalties to the chiffons, whoever owns the rights to that particular song. That's the most famous rap rules. There are specific rules in the music industry regarding rap artists who sample, for example, but it's not based on the number of notes. It's based on other factors. And it's not law, it's simply a policy that the music industry, a protocol that the music industry has adopted as a best practice for people that want to do digital sampling and stuff like that. That's another area. Okay, how do you find the copyright owner? Okay, I got this wonderful thing, I found it on the web, okay? What do I do, okay? The good news is there's a lot of help here. First of all, the Copyright Office will help you. They will actually search the copyright records. You don't have to have an attorney. For a fee of roughly $10 an hour, they will have one of their junior interns search the copyright records and tell you who the copyright owner is for a particular work. Now, there's two problems with that. I don't encourage people to do it. Number one, the Copyright Office is not using their A-team to do this work. You're going to be having a junior intern, a junior in English from Nowhere College, U.S., who happens to know a congressman who got this internship job with the Copyright Office. Seriously, that's what these people are. They're people who are, sons of senators and daughters of congressmen who get, these plum, internships because of connections and stuff like that. How much do they know about copyright research? Nothing. So you don't really know that you're getting good information, number one, on this stuff. And also, number two, let's say, and this happens a lot, let's say that I have a copyright, I assign it to you, but you do not file a copyright assignment with the Copyright Office. You just decide, I'm not going to do that. I'm not going to spend the $80. I'm just going to, I have it, I have the legal right, I'm just not going to publish it, right? Your assignment is not going to show up on the copyright records. So so what's the search going to show up? It's going to show me as the copyright owner, right? And let's say I'm a bad guy. Okay, I'll give you permission, but I want $5,000 from you. So you pay me the $5,000, I give you my permission. All of a sudden, the person, the assignee, comes out of the woodwork and says, hey, I got a copyright assignment from Cliff Enico. You got to pay me royalties too. That can happen. If you do, whenever you assign a copyright to somebody else, it's a very good idea to record a copyright assignment with the Copyright Office. They have a form for this. You don't need an attorney. They have a standard form. You just fill in the numbers with the copyright registration number, and I think it's a $20 filing fee. I don't remember the filing fee, but it's something like that. Always, whenever you assign your copyright to someone else, make sure that the copyright is recorded with the copyright officer. Your publisher will automatically do this. If you have a manuscript and a publisher is publishing your book, they will file a copyright assignment with the copyright, but a lot of other people might not do it. And if they don't, then the copyright records are inaccurate, so you're getting bad information. Another place you can go are collective licensing agencies. In certain industries, such as the movie industry, for example, all the major movie producers have combined their resources, and there's a database which you can access to show you who has the current rights to Gone with the Wind or some classic movie or whatever. Here's another website. Columbia University, the library at Columbia University has a wonderful directory of all of these collective licensing agencies. There are people out there called permissions editors. These are mostly, how can I say it the nice way, laid off executives at publishing companies. Although they're very knowledgeable. These are usually people who are in their 60s and 70s, and they were in publishing and they got laid off, and they want to do something to keep their spouses from going crazy and getting out of the house every once in a while. So what they do is they'll do this research for you. They'll help you, especially for literary works. You can definitely find somebody, even in this area, especially in this area, because we're right near New York. Here. You can find people who, for a very small fee, will help you find out, yeah, Cliff Edico is the copyright owner for that particular work. And there's a wonderful website called Copyright. I don't like the name, but they got a lot of good stuff on there, called copyrightkids.org. And that's the page that has to do with permission. And they have a directory of permissions editors. But quite frankly, it may be possible that SCORE has some retired publishing people here as part of their chapter. Who worked in New York at the publishers for many years. You might have some people in your organization that could actually help with this for a very small fee. So ask the SCORE people if there are any retired book editors or publishing types in the organization. You might be able to do it for nothing. I don't know. I can't say that that's the case. When all else fails, hire a copyright lawyer. The good news is you'll get the right information. The bad news is you're going to have to pay for it. But if it's that important, you might have to do it. Not somebody like me. Please do not call me. Get a lawyer who specializes in copyright. Send me an email. I'll give you some names of some people that I know who specialize in this work, in this type of work. The hardest part of fair use is finding out who owns the copyright. That's the hardest part of it. Because things get transferred back and forth. Remember I told you I have that one book that's gone, that's now on its 4th publisher, right? If you're doing a copyright search on that sucker, you're going to go crazy, before you finally find out where does the bouncing ball end. So you want somebody who really knows what they're doing there. This stuff can get tricky. Okay, now, getting permission from third parties. For example, you're going through a flea market. There's this wonderful photo of some people dancing around a maypole, and you think it's really cool, from the 1920s, 1930s, okay? Or let's say it's from the early 1900s, okay? So we're not worried about public domain. This thing probably, almost certainly, is in public domain after almost 100 years. But what about the people in that photo? Do you got to get permissions from them or their heirs? This actually comes up a lot in the eBay world. I do a lot of work with eBay sellers, and about 2 or 3 times a year, I get an email from somebody, hey, I was at an estate sale, I got this carousel of Kodak slides from the 1950s. Some guy went on a vacation to Peru, and they got all these wonderful photos of the natives dancing native dances and stuff like that. I mean, National Geographic, somebody was going to want this stuff. Can I use it? Well, the issue isn't so much the photos themselves, as long as you can identify who the person. Well, first of all, you got 2 issues there. Number one, you got to find out who the photographer was, because that's probably still under copyright. So the photographer, whoever he was, or his estate, still has an interest in these things. But even more importantly, you got the people in the photos. Do you have to go down to Peru and track down great-great-granddaughter of this person, who's shown in a photo? Okay. Believe it or not, if you read the law literally, the answer is yes. But some of the case law has softened that a little bit. This is not copyright. It's really called the right of publicity. Every one of us has a right of publicity in our likeness, our voice, or image, and what we call a right, and also a right of privacy. Why do you think I told you all to shut up while the video is running? Because if one of you says something, other than a cough or a burp, I'm going to have to get you to sign a release form. You have a right to your voice message. I shouldn't have told you that. This is one of the last slides. I waited until now to give you this one. If I told you this up front, I know what would happen. I'm going to ask a question anyway. Make him come after me. I know you people. There you go. The law is here. Here's the real. And by the way, I found this out myself last year. Last year, I had a college reunion. I won't say what year it was, but I had a college reunion last year. And as part of the reunion, the college, or the organizers of the reunion, set up a Facebook page, and they put up all these wonderful photos from our college years. And there was a photo that they posted. I didn't even know that they had done this. Some friends of mine from college emailed me and said, hey, Cliff, you really want to look at the Facebook page? There's some stuff up there. And there was a picture for a while of me in a fraternity house basement wearing a toga that wasn't fitting very well. And I had a beer in my hand, and I had my arm draped around this poor girl that I don't even remember, you know, who it was. It was probably just somebody who was standing there next to me. They said, hey, Cliff, take a photo. Right? And this person is not my wife and never will be, right? And there was this photo up there, and I said to myself, you know, I probably don't care about this, but I don't think I really want my wife to see this. So I contacted the reunion organizers, and of course, they took it down. In fact, very interestingly, the woman that I had draped my arm around, she had contacted them first and asked them to take the photo down before I got around to seeing it. So that probably says more about me than you probably want to know. But anyway, I thought that was very interesting, actually. I hadn't seen this person like in decades, right? But they got to the reunion organizers before. Nobody wants to be associated with this. Anyway, but seriously, and of course they did. They took the photo down. But that's where I got, you know, hung up on this too. I mean, how many of you would like to see pictures of your college days showing up online in various places? You know, how much do you want to do this? We all have a right of publicity in our likeness, voice, or image. Now, of course, they were just doing this for fun and games. But here's the deal. If you have a photo of, when they say a recognizable person, they're not talking about a celebrity or a famous person. They're talking about a person whose features you could identify. So if you have a crowd shot and all the backs are turned to you, none of those people would be recognizable. But if you can see their face, if someone can make out who they are, that is considered to be a recognizable person. If you take a photo of a recognizable person, someone who could be recognized, and you're using it for commercial purposes, you're not just putting it up on your Facebook page for giggles, but you're actually making money off this, the law says you must get that person's permission. Not under fair use, it's really because if you don't, you're violating their right of publicity. Some of you may remember this. Vampire Weekend, they're a rock band. Some of you hear about this? Their latest album, I can't remember the name of it, but it shows this girl. It was a photo from the 1970s that showed a girl, you know, like walking out of a bathroom, and they took her picture, and she's startled. She's going like this. You know, nothing dirty or anything like that. It's just a headshot from here up. Well, they just found this photo. They thought it was cool, and they used it on their album cover. Well, it turns out the woman is a famous model who lives in Westport here. Actually, she's a local person, and she sued the record company, and she got a multi-million-dollar settlement over that for unauthorized use of. I mean, it wasn't dirty. It was just her like coming out of a room, and she was kind of like this. But she said, "I'm a professional. This does not put me in a professional light. You know, I look like a doofus in this photo." And that, on the basis of that, she got a multi-million-dollar settlement from, you know, whoever the record company was for Vampire Weekend. So that's the famous case there. Okay, almost done. Can you take a photo of a public monument or building and use it commercially? The key here is commercially. As long as you're not using it commercially, you can get away with a lot of things here. But if you're looking to make commercial gain out of these things, that's when the cases come up, okay? Here are my short answers. Yes, if the building is public and you're shooting from public property. So if you're standing, you know, at Rikers Island, you're shooting the Statue of Liberty, no one's going to give you a hassle over that, I don't think. Yes, if you are shooting from within a public building. So you're in the rotunda of the Capitol, you lie on the floor, you want to do the ceiling. That kind of thing is permitted. No, if the building is private residence or privately owned. If you take a picture of my house and say, this is the ugly house that Cliff Ennico lives in, you're looking at a lawsuit, people, okay? Seriously, everybody thinks I'm such a nice guy. That is because you've never been on the opposite side of me in a lawsuit, and you've never infringed my copyright. Okay, those are the two situations where you see the dark side of Cliff Ennico, or in these situations. No, if the building was built after December 1, 1990, it was December 1, and has been copyrighted. Remember, after 1990, buildings can be copyrighted. The Frank Gehry Art Museums and stuff like that, so be careful. That year is important for US copyright purposes. No, if the photo includes monuments, sculptures, or other copyrighted works. So for example, if you're in the Uffizi Gallery and you take a picture of the beautiful ceiling work, well, the owners of the Uffizi Gallery are not going to care, but the people, all the artists whose paintings appear in that shot might have something to say against that. So if you're in the rotunda of the Capitol, by all means take a picture of the ceiling, but try to avoid all the statues, because some of those may actually be copyrighted sculptures, especially if they're of recent vintage. Okay, and then last but not least, and this is very important, the Getty Images people have a database of everything that you cannot photograph without permission. And please, I'm actually going to read it because you all need this. This is not a www, it's HTTP wiki.gettyimages.com. Wiki.gettyimages.com. No www. Okay, it's one of those. Seriously, before you consider using any photo at all, of any kind whatsoever, this advice will save your life. Check this database. This is a database of all photos that are in the Getty Images database, and it's also a list of for example, do you realize you cannot take a picture of the Eiffel Tower at night and use it commercially? Do you know that? Do you know that you cannot take a picture of Ayers Rock in Australia? You know, that big thing in the center of Australia, that thing with all the Aborigines and stuff? You cannot use that photo without permission. Did you know that? This is stuff you will learn in the Getty Images database. You never, ever, ever want to be caught using a photo in the Getty Images database without permission. You never, ever. Getty Images people are ruthless. They sue. They don't send cease and desist letters. They go right to the jugular, and they are nasty. One of my clients set up a website. They used a photo that they thought was public domain, but it was in the Getty Images database. They got a nasty letter saying, call us, and the conversation went like this. When did you post the image on the site? December something, 2008. Okay, that's 5 years, 289 days. We want $10 a day for each day that you were using that photograph without permission, and they would not back down. My client had to cough up that money, or they already had an attorney ready to go to court here in Superior Court in Connecticut on that issue. They are nasty buggers. You do not want to mess with Getty Images. So before you use any photo at all of any kind that you can't identify, check the Getty Images database. Now, what happens if, despite your best efforts, you cannot find the author or the people? Believe it or not, there's a term for this. Copyright people call it an orphan work, like an orphan child. An orphan work means it was written by somebody, but despite anybody's best efforts, we can't find the people who did this. There is a rule of law here in the US that says that as long as you make a diligent effort to find the person, and they're not listed in any of the obvious, let's say you hire a copyright lawyer, and the copyright lawyer comes and says, I've looked everywhere, I cannot find who the author of this photo was or who the photographer was. You are permitted to use it in that case, but you have to be able to justify that you made the effort. If I can go online and find out who the copyright owner was in 5 minutes, it is not an orphan work. You really got to struggle to qualify for the orphan work exception to this whole business. So, here are my key points. You do not have to register a copyright to have one. These are the myths that I have to dispel. You do not have to register a copyright to have one, but you do need proof of publication of some kind, even if it's that poor person's copyright. Watch out when creating works that are based on other people's intellectual property, because there could be an issue of you're creating a derivative work, which is subject to their copyright, and they can hit you up for money. The other thing which is not up there is there are no set number of words or number of notes that trigger the fair use concept. Get that concept out of your head. There's no magic bullet where if you use less than 50 words, it's automatically okay. Every case is different. And then last but not least, always err on the side of getting permission when other people or places get into works that you plan to exploit commercially. If you take a photo of something and you're planning to make money off of this thing, you got to get permissions from the recognizable people who are in that photograph, okay? Here are some suggestions for further reading. The U.S. Copyright Office has over 100, they call them circulars, but they're like little brochures that go into every area of copyright law. It's amazing. And then they're very good, and they're written in plain English. You know, so for example, they have some things on international, all the stuff that we talked about today, there's a circular for it, just about. And they're wonderful, and they're free. They're PDF files, you download them, they don't charge you. This is part of what your tax money pays for. That's where they live. You can take a photo of this, by the way. If you need a copyright Bible, the best one that's out there now is by a guy named Stephen Fishman. It's called the Copyright Handbook. It's about 3 years out of date, though. I think I don't know if he's still doing it or not, or he may have passed. I just don't know. But it is the best thing that's out there, and they also have CD-ROMs with all the forms and stuff like that for, I think it's like $19.95 or $24.95. This is not an expensive book. The best book on fair use that I've seen, although it's a little too general, is Fair Use, Free Use, and Use by Permission by Lee Wilson. Here are the best books, though. If you're looking for books, in every creative industry, there's at least one book that has a very good layman's description of the law, plus forms that you can use. So, for example, if you are a musician, any musicians here? Or music composers, those kind of people? Anybody here? The best book is a book called This Business of Music. It's by a guy named Kravaloski. It's been around forever. It's been around since the 1960s. I think it's in its 50th edition or something like that. It's about 500 pages long, and it has forms, and they're all on CD-ROM. The books are not cheap. They cost usually between $75 and $150, but what you're buying them for is not the content. You're buying them for the forms. That's what you want. If you're a musician, This Business of Music has every form that you need. And it describes the different types of rights, how you can slice and dice them. For $100, it's probably the best investment you ever make. You can probably get it used too on Amazon or eBay or some of these places. For movies, there is a book called, specifically, I think it's also called, there's This Business of Film, which was not by the same guy, but it's the same thing. It's about movie rights. You've written a book, somebody wants the movie rights, how do you negotiate that deal? What are the various types of production contracts? They got forms for everything. They're all on CD-ROMs. Every creative industry, there's one for photographers, there's one for, I didn't have time, unfortunately, to create a slide for all of them, but every creative industry has at least one book like that. If you go to Amazon and try to do a search by price, you'll probably see a book that's somewhere in the $75 to $200 range, and it is this book that would have, not only a description of the law, but the forms that you need, and they're on CD-ROM where you can print them out and fill in the blanks. For those of you who are too cheap to hire a lawyer, those books are solid gold. So try to find the one that applies to your industry. I do have one more thing to talk about. These are some of the books that I've written. These are very general books. They're not going to be as detailed as you need, obviously, for this particular topic, but I do want to let you know that I am an author. And by the way, just to show you that I take this stuff seriously, I'm just going to leave you with two thoughts. First of all, where is copyright law going? Right now, there are a lot of people in this world who believe that the copyright system that we have is very antiquated, and especially in the world of digital rights. With people doing mashups and all kinds of stuff, it is so easy with using today's technology to create mashups and fan fiction and derivative works. A lot of people think that we need to set copyright on its ear. There's a movement afoot. Right now it's mostly academic. It's called the copyleft movement. Next time you're online, Google that phrase. There's some good Wikipedia articles on the copyleft movement. And basically, this is a movement by some academics and politicians to basically change the copyright laws in much the same way as open source software. One area of copyleft law that has caught on is in the software field. It's open source software. Anybody here use Firefox as your web browser? That is an open source program. If I'm licensing Firefox, I get the rights to the source code without paying anything for them. The developers have to make the source code available to me so I can make changes, specific additions, and they don't get a penny for that. That's what open source means. Copyright means the owner owns all the rights unless they give them away. Copyleft takes that and turns it on its ear and says that any work that is created is automatically public domain unless the parties agree otherwise. It takes copyright law and basically sets it on its ear. Now, it's not law today. That's why I didn't do a slide on it. But it's something that is happening, and there are a lot of people who think that this is the wave of the future. The last thing is just to tell you a very personal story. When you have a copyright on something, it is your duty to protect it. If you do not, nobody else will. I told you before about that demystifying the business organization outline. Okay? There are times when I have found out that somebody, it's usually an attorney, by the way, somebody who should know better, has taken this outline, has put it up verbatim, word for word, on their website, and has just changed the name. Believe it or not, I can find out about that. How many here people have heard of Google Alerts? We all know about this? Well, in that 7-page outline, I have certain turns of phrase that are uniquely mine, that only I would say something a certain way, and I have Google Alerts on each of these 9 or 10 turns of phrase. So if you do take this thing and put it up on your website, I will know about it. You will get a nasty letter from me, and I have attorney friends in all 50 states that will come after you. I do not take copyright infringement lightly. Even though this is something I give away, yes, as a user, as a potential client, I'm perfectly happy that you can have this free. But if you're trying to rip me off, dudes, you're going to have a fight on your hands, and you are going to see the dark side of Cliff Enico. Some of you know this now, but Adobe Acrobat, the latest edition of Adobe Acrobat, has a feature now where you can take PDF files and turn them into Microsoft Word files. You can undo the PDF. I hate this. If there are any Adobe people listening to this video, you're going to have some fights on your hand because that defeats the whole purpose of a PDF file. The whole purpose of a PDF file is if you want my outline, you got to print it out and have somebody type the damn thing word for word. But you know, with the latest version of Adobe Acrobat, with a few clicks of a button, you can convert it into a Microsoft Word file and clean it up. So if you're going to do that to my demystifying the business organization, though, you got to make sure that you find all 12 of those turns of phrase that I have on Google Alerts. And if you miss one sucker, I'm going to be all over you like flies on dog manure. And with that, are there any questions? First of all, thank you very much. You've been a very patient audience. I know you've got a million questions, but ma'am back there. Okay, so you're taking pictures of people's comparable houses showing what they've sold for and things like that. I mean, if you're taking it off of a public database like Zillow or something like that?
They have to be
a recent photos of a house. Okay. Technically, that is an infringement. I'm sorry, a violation of my right to publicity, especially if the kids are playing in front of the house. I'm not so sure I want photos of my kids being used for commercial purposes or anything like that. But as you say, it's just the house itself. Technically, it is. Probably people aren't going to mind because even though you're using it for a commercial, you are not making money off of that photo itself. You're not putting it online and saying, here's the ugliest house in Fairfield, Connecticut. It should be knocked down under the blight laws. That if you were doing something like that, put yourself in that position. If I was the owner of that house, how would I feel about that use? I'd be all over you. What you're doing is no harm, no foul. Most of the time, I don't even know the photo's been taken, right? You know, Zillow is taking pictures of my house all the time from their damn satellites. I don't even know that they're doing this. Technically, they're invading my privacy. And of course, if they happen to see me in the backyard relieving myself because I'm too lazy to go to the bathroom, that could go viral. Let's be very honest. You would look for that photo, wouldn't you? That would be a retweet, wouldn't it? You know, this is the world we live in. And I'm surprised, by the way, that Zillow does not get sued more and more for crap like that. I mean, I don't know when that satellite's taken that photo. I have no idea how often they update it, like every hour or something like that. I really don't know. Just be careful. As long as this is what you're doing and it's part of your job, chances are you're not going to get into trouble. However, if someone objects to the use, so for example, if I see a photo in let's put it this way, the listings every week in the newspaper. See, the thing with land records, you're taking data that's off a public record, and I think that's how you get away with that. You know, I mean, anybody can go to the land records and see what my house sold for last week, and that's all public information. I can't make that private. So that's probably how you get away with that. You probably have a
standing on the curb on a public street.
Yeah.
I can't take a picture of somebody's house.
Technically, again, for commercial purposes, the answer is no. If you're taking my house and putting it into a photo montage or something, I have the right to object to that technically. Now, I may not because I'm flattered that you did that, but it is technically that is correct. I mean, as a private, I have a right to the image of my house if I am the owner of that house. If I've given you permission, you can do anything. You know, so for example, if I got releases from all of you, you know, I could take a picture of this guy over there who's been picking his nose for the last 10 slides. I mean, I could definitely do that, you know, and he hasn't been. No, he hasn't been. He's been good. But that's my point is I could legally do that as long as I have a release. And believe me, whenever someone asks you to sign a release, read the language. Because when I draft these things, they are very, very broad. Because I want to cover every possible situation. You know, so for example, sports events. Some sports events, they will ask you to sign a release, you know, so if they take the picture of you going with your little sign, hey, go Packers, whatever, you have given them the right to do that. And of course, if you have a wardrobe malfunction at that point, hey, baby, you're viral. Okay, sir in the back. How does it work for caricatures and cartoons and things like that? Well, Alen, a lot depends. You know who Al Hirschfeld was? He did all the Broadway artists. He always got, you know, consent from people before he did anything. A lot of people don't realize that. He didn't just do, and of course, even when he didn't, these were very flattering. You know, I mean, there were artists who would kill to get in there. I mean, seriously, South Park, you know, the TV show, they do a lot of parodies and stuff, and a lot of that stuff's pretty raunchy. It is. But let me tell you, if they wanted to do a show based on Cliff Enico, you know, one of the South Park kids, you know, has a problem in Cliff Enico, I would kill to have that kind of exposure. So, I mean, I let them do whatever they want to do. I mean, I'm not going to give them a problem, even though it might not always show me in a very positive light. You know, it depends on what you're using the caricature for. If you're doing ugly caricatures of people and selling them as a sort of a dissing thing, you know, not going to, you know, here's Madonna, you know, this is what she really looks like, you know, underneath all the armor and all that kind of stuff. I think you're going to have a problem. See, celebrities have a lot of money, and they are very, very jealous of their images. One of the worst litigants in this whole area is the Elvis Presley estate. They are very sensitive about what you can and cannot do with his images. So my advice to you is, if you're going to do caricatures of public figures, try to get them involved in some way. Talk to their agents. The good news is celebrities are easy. You don't have to worry about finding them. All you got to do is get to their publicist. And they are the ones usually who have the authorization to give permission and do. They're the easiest people to find, the copyright owner. All you got to do is get to their publicist and they're fine, especially if they're still living and breathing. You know, because otherwise you could get it. Again, it all depends on what you're doing. If I see that you've done a caricature of me and it's very flattering, I'm not going to care. I'm going to want it from my website. I'm going to call you and say, hey, dude, I'll let you do it, but I want a free license from my website in perpetuity. And you'll probably do that, right? You'll probably do it. But of course, if you make me look 500 pounds, you know, talk to the lawyer, girlfriend. It's going to be nasty. It absolutely is. Madame, the question is, if you have an artwork or a photograph that you put up on Facebook with a watermark, I'm again, just looking at the language in their user's agreement, I don't think that makes a difference whatsoever. You have assigned your copy. See, all the watermark does is says, I own this copyright, but you assigned it to them in the user's agreement. So now they own it. See, again, I don't mean to knock Facebook. I don't think they intended this. This was a case of their attorneys getting a little sloppy, and I think they will correct this eventually, because a lot of people in the artistic community are raising holy hell about this. So I think they are going to change it. What they meant to do is, if we see something you're doing that we really like, and we want to promote it to the whole community, we have the right to do that, and you can't say no. We don't have to go back to you and get your consent. They intended the right thing, but the way they worded it, it's a standard assignment of copyright clause that I would put in some of my contracts. So it picks up a lot of this stuff that they probably didn't intend. They probably, by the time this video comes out, they may have solved that problem. I hope they will. They are definitely aware of it. Believe me, the artistic community and ASCAP and some of those people have really been all over them on this stuff. Yes. No, I'll let you ask a follow-up. Correct. Facebook's user agreement does not allow other people to rip you off. Now, of course, they will. And that's where the watermark comes in real handy. If somebody else is trying to rip you off and they're using it and they're saying it's their photo or something like that, that's where the watermark protects you. But it will not protect you probably, given the way that language is written. But they would have. But I would even think that if they did something really nasty with your photo, you know, you probably might be able to do something even with that. If I were the lawyer, I would definitely take the case on and give it a shot anyway. Although it's a real David and Goliath, situation. Ma'am in the back in the striped shirt. What about LinkedIn? Okay. I have not read LinkedIn's user's agreement as yet, but what you want to do is you want to look at it. If there's any clause in there that says assignment of rights or assignment, if the word assignment appears in any of the law paragraphs, show it to your lawyer. I think that would be my question. Okay, it's very hard to do an assignment clause without actually having the word assignment in the title. So just take a look at that. And I don't know. I mean, given the fact that it's LinkedIn and it's for professional use, I gotta believe they're a little classier about that. But that I never assume. Okay, Madame in the blue over here, you had a question. So you got a blog. You're using photos. You're giving photo credit, which is good. That means the photographer cannot come after you, which is good. That's a good thing. But what I would do as a precaution, I would check that Getty Images website. If you learn nothing else tonight, whenever you're thinking about using a photo on your website, your blog, even if it's something where you think it's clear as heck where it's coming from, check the Getty Images database, because if it's one of theirs. So for example, remember the photo at the end of World War II, the sailor kissing the nurse in Times Square? That's in the Getty Images database, and that's still under copyright. You cannot use that photo without Getty Images permission. Seriously, they are nasty people. Seriously, I mean, I have never won. I mean, I'm pretty creative at cutting deals in situations like that. I have never won a fight with Getty Images at all. They go to court and they sue, and they're nasty. Yes. That's the photo of me with this woman from 40 years ago, the drunken photo. That's the kind of stuff. You have a right of publicity. You don't have to be a celebrity. This is for anybody. We all have a right of publicity and the right to decide how our images will be. I mean, there are some exceptions to it. There's something called a journalism. Do you remember the Vietnam War photo of the girl running down the street naked with the napalm and stuff? That, if the story has journalistic merit, that, she can, by the way, and she's in California actually. She actually tried to sue for copyright infringement on that, but she lost the case because if it's part of a viable news story, so people running out of the World Trade Center after the bombing, there's always a journalism exception and a news media exception if it's part of a viable news story. If it's a celebrity profile, though, maybe not. I don't know if that's journalism or not. But if it's Kim Kardashian, as Zsa Zsa Gabor once said, this is probably the best quote at all on the right of publicity. Zsa Zsa Gabor said, "There is no such thing as bad publicity." Some celebrities take that view. So here's a good example. Did you see the art thing on Yahoo about Arnold Schwarzenegger today? He was at one of the Madame Tussauds House of Wax, and he decided he was going to have some fun. So they took his statue out, and he got out in there in the Terminator outfit. And some people, they would go take their picture with him, and he'd go like this. First of all, I think that would be third-degree assault in Connecticut. Let's put it that way, and scared the crap out of these people. Obviously, I mean, how would you feel? You're just having some fun. But also, too, I mean, think about it. Can they take that photo and put that up on their face? Well, I'm sure he'll be okay with that. But seriously, I mean, what about something like that? I mean, can Arnold Schwarzenegger use that photo as part of his? Well, I'm sure that he'll get releases and stuff. I'm sure that his people were there when it happened. Sir in the orange cap. The answer is you can get permission from the Getty, and believe it or not, their agreement is actually quite reasonable. It really is. I mean, if you're asking for permission, they turn into pussycats. They do. Their agreement is not that horrible. They want like $100 or something for a perpetual use or something like that. It's when they catch you using it without permission that the dark side, because the claws come out with these guys. Madame, right here. This is a collage artist. I will give you my business card at the end of the program. No, seriously. No, seriously. Somebody in your field needs a very, very good copyright lawyer because of exactly these kinds of questions. It's the whole mashup thing. A collage is a mashup. It's the same exact thing. So you have this whole issue of can I use, at what point does it become a transformative work? That whole thing about the derivative work. You're taking David, but you're putting him on a stalk of broccoli or something like that. I mean, this is the kind of stuff that people do all the time. And as long as it has, I mean, I hate to say it, but it's almost the same standard for obscenity. If there is redeeming social value, it's not considered obscenity. There's a Supreme Court standard for that if you're familiar with that. It's kind of the same thing. As long as you can argue that the work can stand on its own as an independent work of art, then you should be okay. And obviously, if the whole work, if the eye from the famous statue is 90% of the work, of the total collage, that's when I would start getting a little bit more concerned about things. If it's one of 500 images that you're using, because let's face it, the mashup people, the robot chicken people, they have this same issue with every one of their shows. In a lot of cases, they can't get the permission, so they just go ahead and they do it anyway, and they hope that people have a sense of humor. I mean, I think that's what a lot of what happens here. And again, if they're helping promote the original artworks and get people interested in them, again, it's something else. We'll have a conversation, but seriously, someone in your field needs to know a good copyright law specialist. You're beyond the 101 level here. Actually, that's a case I have never seen. A case where somebody sells the underlying painting, and then because of an infringement problem, somebody has to destroy it. Does the customer at that point have recourse against the artist? I've never seen that case yet, but it's one that I think, at least theoretically, could possibly happen, but I've never seen it. Sir in the back, if you're putting copyright on your website, can you just put it on your home page and not the interior? I always suggest to people to put it on the bottom of every page. It's a footer, just like a footer on a Word document. It takes your web person 2 minutes to do this. It's not going to cost you a lot of money. And also, too, it sends a signal that you're a badass who's not to be trifled with. That's another reason why you do this stuff. If I'm looking at something and I see copyright notices over the place, that's a way of saying, don't mess with me. Don't tread on me. That sends that signal. And that can help you in a lot of borderline situations. I mean, I've had clients show me stuff, can I use this? And if I see copyright notices over the place, you know what, this person's nuts. I would call and ask for permission. That's exactly how I say. Madam in the glasses back there. Now, you're a PR person, and the question is, she's doing proposals, and she puts copyright notices. Is this part of your employment? Are you working for a PR firm?
No, I have my own company.
You have your own company. All right.
I'm working with very large clients.
No, absolutely nothing wrong with doing it that way. In fact, I would recommend that you do that because it sends to others. If somebody else wants to rip off that proposal in some way or that form or something like that, I mean, there are certain exceptions. So, for example, there are technically there's no copyright on legal forms, for example. If you take a legal form from a form book and that's what it's there for, so there's no copyright on stuff like that. And very often, I mean, I have clients who very often will sue people over very small amounts of money, even though they know they're going to lose, they're going to come out a loser, because they want to send the message that you do not mess with this person. Getty Images, why do you think Getty Images does what they do? Because they're sending the message, do not mess with Getty Images. Your life will head south. I mean, that's their message. We're a mean motor scooter and a bad go-getter. We come after you. And that sometimes is the best way to protect yourself in situations. I mean, part of my problem is I'm such a nice guy. People think that I'm that way as a lawyer, too. And as I say, there are two things you never want to do with Cliff Ennico. You don't want to be on the other side of me in a cat fight, and you do not want to infringe my copyright on stuff. Those attorneys that try to rip off my demystifying the business organization law, you do not want to be the recipient of that email. Let's just put it that way. I can be nasty when I want to be. Madam,
For the trademark.
we're talking about websites here. The website itself cannot be copyrighted, but the content, the original content, can be. That's on the website can be copyrighted. The domain name, you have to register, but you also can get a federal trademark for it, and I recommend that you do. A federal trademark beats everything that's out there. If you have a federal trademark for, I'll use one of mine, Bienix. It's the name of a company that I ran for 10 years. Nobody else can operate a similar business using that name. Okay, if we're talking about a name or a domain name, we're talking trademark. We're not talking copyright. And that's a different universe. Maybe if SCORE lets me, I'll do a trade program at some point, because that's a whole other area of law. But the bottom line is, if you have a unique, by the way, but I will give you one piece of advice, though. The best trademark is something that has nothing to do with what your product or service is. What does Monster have to do with looking for jobs online? What does eBay mean? Anything. It's just a made-up word. The best trademarks are made-up words that don't exist in the dictionary, or words that are totally unrelated. Turtle brand chocolates, or something like that. Words that have nothing to do. If the words Joe's Garage, if you have a garage and your name is Joe, you cannot trademark the name Joe's Garage, because it's descriptive. And descriptive things that are descriptive are not trademarkable. However, someone does have a trademark for Joe's Garage, but it's not in order. Frank Zappa. That's right, in the field of music and recordings. It was one of his movies back in the 70s that he did, Frank Zappa, but for music, not for, if he was running a garage, he wouldn't get away with that. But for a record album or a movie, calling it Joe's Garage, you can definitely trademark for something like that. Trademark's a whole different area. Ma'am, you had a question. This is the eBay question that I get all the time. I got these photos in the attic from the early 1900s. If there are recognizable people in them, and especially if they're like politicians, like the governor shaking hands with somebody, you know, there might be. Otherwise, I say to people, if it's that old, I mean, legally, technically, you might have to get some consents from if there are recognizable people. If it's just a crowd scene, no recognizable people, then you're probably going to be okay. If someone has a problem with it because it shows your her great-grandfather with her knickers up or something, blown up over her head or something, they will send you a nasty letter, and you'll have an opportunity to deal with it at that point some way. You're not going to get sued over something like that.
The city can't take over.
The answer is no. However, I will say that there are some cities that are trying. St. Louis, for example, right now is trying to get the arch as a trademark, and as part of that, they're going to take the position that this is something that you really shouldn't be taking pictures of. Seriously, look at the Getty Images list of places you cannot. It will boggle your mind. Some of these, I would never have thought that taking a picture of the Eiffel Tower at night and using it for commercial purposes. If I'm just putting it in my photo album of my vacation, no problem. But if I'm using it for commercial purposes, the city of Paris bans that. It's not the Eiffel Tower. It's the city of Paris, the municipal government of Paris. Yes, in the white. If you're an event planner, unique concept, unique logo for each event.
Yes, for an event.
Okay.
And it was a public event.
Right. These are public events.
Can I protect the concept and logo?
Okay. The logo is no trouble. That's a trademark. It's not a copyright. That's a trademark. The concept, though, is harder to protect. So the idea of a Dungeons and Dragons themed bar mitzvah, for example. I mean, that idea, I don't think, that just the concept, the actual name though, some of the actual like sculptures, the original artwork that you create, yes, you can copyright that. But the idea, anybody can exploit an idea. Ideas are free in commerce. That's the idea. Sir, over here. Okay, the question is, if you have an artwork, artworks are tricky. You can't do the poor person's copyright with artworks other than photos. Right. Well, photo, yes, you can reproduce, right. You can do 10 copies of the print and mail a couple to yourself. Do more than one. I always suggest do like 2 or 3, because sometimes you lose them, they get burned up in fires and stuff like that. You know, put them in a safe deposit box. I tell clients sometimes to put them in a safe deposit box. But if it's an original artwork, obviously you can't do that. Certainly posting it on Facebook would be evidence, it would be proof of publication, it would be proof of when you created the work, which is what you're looking for, but I wouldn't do it on Facebook. As I said during the talk, I would put it on your website and then link from Facebook. Have saying, hey, to see my latest artwork, click here, and then have a link to your website. That should be okay. That gets you out from the Facebook. No, because again, and by the way, seriously, forget copyright law. As a business proposition too, And artists are terrible business people in general. Forgive me. Everyone that I've ever worked with, they're terrible business people, and that's fine. That's not what they do. Your best work should always be on your own website. Every artist needs to have a website of their own, and that's where your best stuff should be. Why? Well, partly because of the copyright stuff, but also, too, there's only one place on the entire internet where you can sell stuff and keep 100% of what you make. Guess where that is? Your own website. If you're selling your artwork on eBay, that's great, but they're going to take a huge chunk of every sale, right? The only place on the internet where you can sell stuff and keep 100% of what you make is your own website. That's where your best stuff should be, and everything else you do online should be feeding people like the tentacles of an octopus to your website, because that's where the best stuff should be and your highest margin work should be. Madame, over here. Okay, if you've written a screenplay, should you copyright the screenplay? Absolutely. The copyright notice should be at the bottom of every page as a footer. Okay?
But if you create a film based on the screenplay.
Okay, and then you go and create a film based on the film. So you're not only the screenwriter, you're also the producer, which is smart because the producers make a lot more money than the writers do. So that makes a lot of sense. The answer is the film would be a separately copyrightable. It would be a derivative work of the screenplay, is how I would look at that. But I would also recommend that you separately copyright the film as well, especially if the film deviates. This issue, by the way, any Game of Thrones fans in here? This is a big issue that's happening with Game of Thrones, because in the last season they started deviating from the George R.R. Martin books, and I think there's some tussling going on between him and the TV producers about, is this a derivative work? Is this, that kind of stuff. This, when a film or a TV work deviates from the original game plan, you get into these kinds of questions. Okay, and let's see, man back there. If you go to Paris and take a picture of the Eiffel Tower at night, you just put it on your blog? No, unless you're making money off it. Unless if this is a commercially subscribed thing, where people pay a subscription fee or something because of stuff you write about, if you're a travel author or editor, perhaps, something like that. Otherwise, I mean, if it's just for your personal use, nobody cares. But the problem comes up 100 years after you're dead. They find these photos, and there you are, you're in a picture next to somebody who turned out to be a famous terrorist or something like that. And believe it or not, there are cases like that. You're taking a picture, and does anybody remember the episode of the Dick Van Dyke Show? This is really going back, where his uncle Hezekiah dies and leaves him this photo of himself, holding his son, and way in the back there's this little shadow that turns out to be a picture of Abe Lincoln at Gettysburg. You remember that episode where there's this guy standing, and it turns out to be Abe Lincoln? It's an original Matthew Brady photo of Abraham Lincoln, that's worth a ton of money. I mean, that's the kind of stuff that it might, where that kind of might get a little bit out of hand. Anybody else? We got room for 2 or 3, and I want to give some people here a chance, sir. So the question is, you take a picture of a monkey. Okay, rather than try to answer that, let me tell you what you should do. Get a bunch of different pictures of a monkey of different kinds of monkeys and do a composite. That way, you have an original monkey that does not exist anywhere. So that way, the monkey rights people will also not be after you, too, which is another thing you have to... No, seriously, animal rights people can be nuts sometimes if you do a work... The Curious George books, by the way, are under attack right now from some of the animal rights circles because of the way he is depicted, and stuff like that. So seriously, there's other reason beyond copyright why you want to make this as original as... You're a collage artist. You two should be working together. You're exactly in the same... Okay, Madam in the back, orange. This is a site where you're licensing them to use your... Well, you have to look at their terms and conditions, okay? Always, forgive me, whenever you're talking about putting your work on another site, always read the terms and conditions or have your lawyer look at them. Seriously. This is not one of those things where you click I agree and nobody worries about it. You may be giving away, you may be selling your rights. You may be assigning. I don't know about Zazzle, but I am aware of a website that does T-shirts based on your original artwork, and unfortunately, they take an assignment of your copyright for wearing apparel, not just for T-shirts. But the way the language reads, I saved a client in this situation. He wanted to have some T-shirts made up, but as part of this deal, you were assigning for all wearing apparel. So if Christian Dior called that website and wanted that your artwork for other types of wearing apparel, you would not have gotten a penny out of that as an artist. So be careful. If it had just been for T-shirts, and I can understand why they would have wanted that, because they don't want you dealing with 5 different T-shirt companies, they want to limit competition. That could be okay as long as it's for a limited period of time. Licenses are always the way to go. When in doubt, license, never assign. Okay, the other question, sir, with the goatee. You do Lego things of buildings. Any buildings after 1990?
Not yet.
Okay, that's good.
Requests.
All right. Lego, I know, has a whole website for Lego artists. I don't know where it is, but I know they have specific rules specifically as to what you can and cannot do with their stuff. They encourage this. This is nothing, you know. Absolutely. You know, I mean, obviously you have to make sure that you give them credit. I mean, how can you say it's a Lego sculpture without using the Lego trademark? I mean, you simply can't do it. I would say, though, be careful about what you do. I mean, you are an artist. It's the same as if you're taking a photo of the Eiffel Tower. Building a Lego model of the Eiffel Tower and taking a photo of the Eiffel Tower, to me, are exactly the same process. From a copyright point of view, not from an artistic point of view, but from a copyright point of view. Okay, last question from the gentleman over here in green stripes. Okay, so you created a logo for someone. They didn't pay you for the old version, but now they've done a derivative of that. Did you assign, my question for you is, what did your contract with them say? Did you assign your trademark, all your rights to them? Is there an assignment clause in your agreement? No, you need a good lawyer. No, bottom line is you need a good lawyer. Technically, if you did not have an assignment clause in your agreement, they changed your work without your permission, even if they had paid you for it. That's the Reed case. Even if they had paid you, they changed your work without your consent, which they didn't have permission to do. So you have every right to, from what you've just told me, you know, not knowing any other details of this, I think you have every right to pursue it, and you should definitely speak to an attorney. Give me a call. I don't do this kind of work, but give me a call, and I'll be happy to make some recommendations for you. Listen, guys, it's 8 o'clock. You guys have been wonderful. Mike, you have a few more words to say about